major freedoms including the rights of women, children, youth, elderly and people with extraordinary needs, as well as the conservation of Islamic family values. 10-year Program of Action or TYPA. This instrument, adopted by the OIC heads of state and government in 2005, acts as a cornerstone of the institutional reforms embarked on in the year. The TYPA has developed with the awareness of the potential for the Muslim world to realize Renaissance and to take practical stages towards consolidation, the connections of Islamic unity, achieve union of ranks and project the correct image of noble values of Islam and its civilizational attitudes. As part of a larger development of the OIC, the TYPA introduces a clear concentration on universal human rights and the significance of mainstreaming them into all programs and accomplishments specifically on human rights and democracy. Islamic humanitarian intervention. The Islamic Cooperation Humanitarian Affairs Department, ICHAD, was established in 2008 in order to look after the humanitarian issues and what OIC needs to do. Under the Humanitarian Affairs Department, the OIC has given importance to the matter of disaster risk reduction and the obligation to reduce the loss of life, livelihood and economic properties through natural disasters, an initiative which searches for acceleration of the universal operation of the Hyogo Framework of Action 2005-2015 and the growing role of disaster risk reduction efforts and initiatives it is playing in the OIC members' national policies. In this manner, ICHAD, which is the OIC principal point, closely cooperates with the League of Arab States and other institutions, for example, of the Saudi Arabian Presidency of Meteorology and Environment and the Islamic Development Bank. At the time that OIC is emerging as a significant humanitarian actor, the OIC has also advanced partnerships with the official humanitarian sector, including the United Nations Secretariat, the World Food Programme WFP, the United Nations High Commissioner for Refugees UNHCR, and the UN Office for the Coordination of Humanitarian Affairs OCHA. From the perspective of the formal humanitarian sector, these partnerships not only symbolize an acknowledgement of the developing role of the OIC, but also an optimism that the latter's Islamic identity can assist in developing new tactics to humanitarian action in the Muslim world and facilitate access to the zones controlled by the Islamist movements, opposed to the provision of aid by a system that is largely seen as Western, which is by United Nations. The Council of Foreign Ministers of OIC, by its resolutions in 2011, commends the efforts made by the Humanitarian Affairs Department to alleviate the sufferings of the needy people in different OIC member states struck by disasters and calamities, particularly in Gaza, Libya, Somalia, Niger, Yemen, and so on. It also appreciated the work done by the OIC funds in Afghanistan, Bosnia-Herzegovina, and Sierra Leone. Let us talk about the OIC Independent Permanent Human Rights Commission, IPHRC. The Commission's founding statute was adopted in 2011 as per the Charter of the OIC. Article 15 of the Charter stipulates the broader mandate of the IPHRC as promoting the civil, political, social and economic rights cherished in the organization's covenants and declarations and in universally agreed human rights instruments in conformity with the Islamic values. According to the statute of the Commission, its mandate is limited to carrying out consultative responsibilities for the Council of Foreign Ministers and submitting recommendations to it rather than investigation human rights violations in member countries or undertaking protective functions. The IPHRC is composed of 18 specialists of well-known distinction in the issue of human rights. 6 members from each geographical region group, Africa, Arab and Asia, represented in the OIC, nominated by member states and nominated by the Council of Foreign Ministers for a period of 3 years. It is pertinent to note here that the establishment of IPHRC symbolizes the increasing prominence of human rights and institutional reforms within the OIC and its desire to increase its relevance and legitimacy among the peoples of member states and endorse its credibility at the international level as well. According to a report of the Asia Forum 2014, OIC Commission on Human Rights as an initiative is growing its influence in countries like Turkey, Morocco, Indonesia and Malaysia, whose approach to human rights may differ from the traditional players of the OIC members like Saudi Arabia, Iran and Pakistan. On 21st March 2021, the OIC Commission joined the international community in observing the International Day for the Elimination of Racial Discrimination 2021 and reiterated the importance of recognizing, addressing and eradicating all forms of racism and ethnic oppression across the world. The body emphasizes the role of Islam in this context, and it says, the Commission underscored that Islam categorically prohibits all forms of racism, discrimination and intolerance. It is among the fundamental principles of Islam that all people are equal and enjoy equal rights and responsibilities, regardless of their caste, creed, color or faith. Combating racism entails respect for diversity, multiculturalism, inclusiveness, democracy and the rule of law, which are core values needed to enjoy human rights and fundamental freedoms by all. OIC Plan of Action for Advancement of Women. In order to achieve the goals set in the 10-year program of action, OIC adopted the statute of OIC Women Development Organization in May 2009, with the sole purpose of promoting women rights in the member countries. The organization, which is based in Cairo, Egypt, is expected to work for the development and promotion of the role of women in the OIC member states with capacity, talents and competence building through various mechanisms including training, education and rehabilitation in line with Islamic principles and values. In Article 5, Clause 1 of the founding statute of the OIC Women Development Organization announces that it should highlighting the role of Islam in preserving the rights of the Muslim women, especially at the international level. Organizational objectives and mandate outlined in the statute do not allow OIC Women Development Organization to engage directly in the women's rights discourse with the OIC member countries. Instead, its objective appears to be facilitating women's participation in development and countering the negative stereotypes of women in Muslim societies. Finally, safeguarding and endorsing the rights of Muslim minorities in non-OIC countries is one of the primary responsibilities and objectives of the OIC. OIC's engagement with situations involving Muslim minorities has been oriented towards mediation, conflict resolution, and providing humanitarian support rather than direct intervention on issues related to human rights violations. In Asia, OIC's involvement had in the past been visible in their mediation efforts in the Philippines and Thailand between the governments and Muslim separatists. efforts to resolve the communal conflict in Myanmar between Rohingya Muslims and the majority Buddhists have been particularly important. The OIC-WDO held its 7th Ministerial Conference on the role of women in the development in the OIC member states in the session of Women Empowerment in Member States, Challenges and Prospects. It was held in Burkina Faso from 30th November to 1st December 2018. However, the question remains whether OIC is open to hold itself to the same standards it demands from the non-member states when it comes to Muslim and non-Muslim minorities in OIC states, given increasing reports of abuse of the rights of such minorities in many OIC member countries. The ambit of OIC Plan of Action for Advancement of Women has increased with the passage of time. There is no doubt that for better compliance of human rights, the regimes must be culturally constructed, which further means they must be articulated keeping in context the historical, political, cultural background of the country or the region. However, while doing that, the universal values must be upheld. For example, basic rights cannot be denied in the name of religion or religious practices. The problem within the OIC over human rights understanding has been highlighted by Turan Kuglo in following excerpt. Most OIC leaders believe that human rights should accommodate Islamic values. There are 3 groups within the OIC leadership: radical relativists who deny any legitimacy to the United Nations human rights system. Secondly, strong relativists who argue for the compatibility of Islamic and universal human rights to some degree, but ultimately prioritize Islamic compatible rights while interpreting universal rights and rejecting universal rights in the instances of apparent conflict. And thirdly, moderate universalists who also argue for the compatibility of Islamic and universal human rights, but prioritize universal human rights and are thus more willing to interpret Islamic values in a way to make them conform to the universal rights in instances of conflict. Such a situation points at a hopeful position of the Islamic human rights system because there is presence of a more holistic approach towards human rights. It might take a little more time to come to fruition, though. It is not important to embrace Western particularities of human rights narrative in the Islamic narrative of human rights. Rather, one must look forward to a unique model presented by the Islamic world. That would be actual contribution in making the human rights holistic. The Cairo Declaration of Human Rights in Islam was presented to the United Nations in 1992 and it was accepted into Human Rights Commission's compilation of international instruments in 1997. This action is arguably viewed as a consecration of the document by the United Nations, that is, by virtue of resolution number 49/19-P on the Cairo Declaration on Human Rights in Islam. Since then, the Cairo Declaration of Human Rights in Islam, CDHRI, has formed a part of the International Instrument on Human Rights. Creation of international law of blasphemy is also very interesting to note. Although the status given to the document is that of a regional instrument, the universality of its application across globe cannot be disputed. This is so because its sponsor, which is the OIC, is a universal body comprising 56 states of the world. Moreover, the CDHRI has been observed as the sole legal source behind the modern proclamation of international law of blasphemy by the United Nations. The UDHR or any other international instrument does not contain provision for international law of blasphemy. This is, however, one of the effects of its publication by the United Nations Human Rights Commission. The Defamation of Religions Resolution of 2005 was brought to the Human Rights Council by the OIC with the intention of protecting all religions from defamation, thus making a blasphemous act a human rights violation and a crime. The United Nations Human Rights Council adopted the resolution by a vote of 21 to 10, regardless of several EU countries' concern that religious defamation laws would be used to limit freedom of speech. The Covenant on the Rights of the Child in Islam entered into force on 28 June 2005 as it was adopted by 32nd Islamic Conference of Foreign Ministers in Sana'a, Republic of Yemen in June 2005. Article 24 of the Covenant provides for the implementation mechanism of the Covenant. It says, states party to the present Covenant agree to establish an Islamic Committee on the Rights of the Child. The committee shall be composed of the representatives of all the state parties to the present Covenant and shall meet every 2 years, starting from the date of entry into force of this Covenant, at the headquarters of the OIC to examine the progress made in the implementation of this Covenant, and the proceedings of the meeting, for which 2/3 of the state parties to the present Covenant shall constitute a quorum, shall be governed by the rules of procedure for the meeting of the conferences of the Organization of the Islamic Conference. The Covenant appears to be a step in the right direction. However, it fails miserably once analyzed. The very first article of the Covenant fails to define who is a child and simply mentions a child means every human being who, according to law applicable to him or her, has not attained majority, thus leaving it to the parent state to deal with the question. Further, in Article 3, it mentions that the Covenant is to observe non-interference in the internal affairs of any state, which again leaves child victims at the mercy of the state. There are concerns which are not addressed in the Covenant related to the children in armed conflicts and their rights vis-a-vis armed forces. The Islamic interpretation of human rights would not only be followed by the Arab countries, but a significant part of Africa, South Asia, as well as Southeast Asia, and everywhere where we have followers of Islam and practitioners of human rights. We must give OIC more time to come up with a more effective mechanism and more embracing human rights approach, with the hope that all human rights initiatives will bring good to the quality of human life. That should be all for this lecture. Take care and bye for now.
Hello and welcome to channel number 6 VIDHIK. We are offering a course on human rights, international humanitarian and refugee law. Under this paper, we have interviewed Dr. Christian Moliner, who studies migration and mobility. Migration and mobility is an interdisciplinary subject which is important for students studying different disciplines of knowledge, whether it is students of law or it is the students of history, journalism and mass communication, or any discipline of social sciences. Enjoy this conversation. Hello and welcome. Today we are going to talk about migration and mobility. As we all know that a lot of people across the globe are all the time on the move. Approximately 4% of the population is considered to be on the move from one country to another country. As a result, migration studies have become really important. So today we have Dr. Christine Moliner with us. She is working as Director of Migration and Mobility Studies in OP Jindal Global University. Welcome to EMRC studio, Dr. Christine.
Thank you so much.
So first of all, just can you just give us the background how migration studies have grown as a subfield of sociology?
Right. So initially, if you look at the history of migration studies, it started approximately in the 1920s, 30s in the US. And it's a product of mass migration to the US across the 19th century, initially coming from Europe, afterwards coming from Asia, South America. And it is a product of an eagerness on the part of the country and its administration, its state authorities to try and make sense of that phenomenon and make sense of the impact of mass migration would have on the country. So from the very beginning, what is striking with the field of migration studies is that it is dominated by the perspective of the destination country, and it is dominated by a perspective from the state. So it's initially very much a policy-oriented field, and later on, particularly anthropologists have developed another perspective that tends to address migration from the point of view of the migrants themselves, so a human approach of migration, or looking at migration from the lens of the migrant experience itself.
So if we talk about the Europe experience, is it still destination oriented studies, or we have some kind of difference from the earlier?
So broadly speaking, if you look at the field in general, whether research is conducted in Europe, whether it is conducted in the US, so in the global north, let's say, it's still very much a global north centric type of social field, social research field. And the global south, which is an area of origin of those migration flows, global migration flows, is still to develop its own tools, its own methodologies, and its own research, trying to understand the impact of migration, not anymore on the country of destination, but on the country of origin. So this is yet to happen.
Okay, so just let me take you a bit back. When we talk about migration, particularly about international migration, a person from one country is going to migrate to another country. That will bring immigration laws, visa norms into the account. That very idea of visa norms, and other entry points, etc. These are all legal points where the destination country is important. Doesn't it mean that the destination country by default is going to be the center of studies?
You are quite right, Daljit, and this is probably one of the issues with a policy-oriented migration research. I argue that it also needs to take into account the point of view of mobile people, not just the point of view of the state. But if you allow me to little bit elaborate about the link between migration, law, legality or illegality, I think it is important first to talk about terminology, because terminology, I mean the categories and the terms we use are extremely important in general, but even more important in the context of migration, which has become a highly politicized topic, particularly in the destination countries. So many scholars like me, along with activists, prefer not to use the term of illegal migration, because the term illegal tends to stigmatize migrants, and instead of talking about illegal migrants, we prefer the term of undocumented, because undocumented is a more neutral term. Nonetheless, we need to study illegality, so the concept and the notion of illegality, but we approach illegality not as a given or not something as a natural category, but something that is constructed. So I will argue that illegality in the context of migration from the global south to the global north is a category or is a notion that is imposed and that is constructed, is a legal and political category that is imposed and constructed by the state in the destination country, and that needs to be approached as such, that needs to be studied as a construction, not something that is natural.
How do that construction or that very nomenclature that so and so is illegal change when you call the same person undocumented? So the document in itself is a creation of state. So just elaborate on that point.
So basically this is not taken for granted that migrants need visas, passports, documents, papers to migrate. This was not always the case in the history of humankind. And to make sense of that illegality, that construction of illegality by the state of in the country of destination, I think we need to understand how illegality has become the major lens through which the state in the global north, so the state in the country of destination, has come to see labor migration from the global south. And to enlighten that process, I need to go back a little bit in time. So starting briefly with the 19th century. So 19th century is the century of when migration becomes a mass phenomenon. It is also the period when migration, so at that time, if you remember, it's mostly European migration to the US, but also colonial migration. For example, millions of Indians have migrated as indentured laborers in the British colonial empire. So in the 19th century, migration is both becoming a mass phenomenon and is also becoming politicized because of the emergence of the nation state in Europe. And if you look at France, nonetheless, at that time, migration in France and Europe in general, although I argue that it is becoming a mass phenomenon earlier and it is becoming politicized, nonetheless, if we go to the 20th century, second half of the 20th century, from the 1950s, so the post-World War period till the 70s, the main way to look at migration, so the main way the state in the country of destination is looking at labor migrants is through an economic approach. So the migrant is just a worker and is only legitimacy to be in France, in UK, elsewhere in Europe the work he does is labor force, And this will remain the case till the 1970s. So what happens in the 1970s is we have a complete shift in the nature of migration. Till the 1970s, as I said, migration was mostly understood in economic terms. And as far as nature of migration is concerned in Europe, whether we look at the UK or Germany or France, we have a temporary migration comprised of men, young men, who see themselves also as temporary settlers. They will work in, at that time they work in the, mostly in the industrial sector, in the mines, in the automobile industry, in the heavy industries. And they perceive themselves, and they are perceived by the country of destination as a temporary phenomenon. So labor migration then is considered as temporary. And what changed in the 70s, late 70s and early 80s is a major shift in the nature of that immigration from a temporary, entirely male-dominated phenomenon. It becomes a permanent phenomenon. So migration becomes permanent, and this happens with the reunification of family members. So the complete shift in the nature of migration is also accompanied by the heightened politicization of migration, intense political debates and conversations and controversies, particularly in the UK and in France, about the place of migration, the role that immigrants are expected to play in their country of destination, and increasingly the framing of migration as a problem, which it was not before, because migration and immigrants were there to fill labor needs.
Okay, so I'll take you just a bit back. If we go to 1950s or late 40s, that is a major shift is happening across the globe as there are a lot of countries becoming independent after long colonial rule. So during the colonial period, the migration was managed by the state, whether it is indentured labor or it is army recruited from the colonized countries. But thereafter the migration is entirely different. First of all, there are a lot of people migrating from erstwhile colonized countries to the colonial powers, which now they are no more colonial power. And the very phase, that is post-colonial phase, completes in next, say, 20 years, from temporary labor to, as you call
permanent.
that now, the permanent, and they can ask their families to join them over there. So if we revisit this process, the process of 20 years with the reference of colonialism, does it make some change?
So the colonial heritage is illegal, so has been illegalized by the state in let's focus in Europe. But something we have to take into account in trying to understand this political construction of illegality, of illegal immigration, is the role played by the European construction. So I think it's probably more salient an issue than as salient as colonialism. So if you allow me to discuss that right now. So what we have is a European construction from the Rome Treaty in 1957 onwards, allowing a progressive dismantling of internal borders of Europe, okay, which meant free movement of people within those internal borders. So a parallel movement